Hello and welcome. Thank you for joining us at Digital Leaders Public Sector AI Week 2026. My name is Nicola Cain. I'm the CEO and Principal Consultant at Handley Gill Limited, an award-winning legal and regulatory compliance consultancy with specialisms in responsible AI, data protection, online safety, content regulation, human rights, ESG and GRC. Today's session is entitled Live Facial Recognition AI, From Recommendation to Reality, and with reference to the Live Facial Recognition Adoption Project on which we advised Hampshire and Isle of Wight Constabulary, and for which we were joint finalists at the PICCASO Awards in the Responsible AI and Data Ethics Initiative or Leadership category, we are going to demonstrate how your public sector organisation can successfully implement artificial intelligence lawfully and ethically, whether that's a complex live facial recognition project or another AI implementation. During today's session, we will address capacity, capability and culture, how to determine your approach, establishing governance, procurement, risk management and due diligence, legal and regulatory compliance and ethics, how to take a step backwards to ensure you spring forwards, consultation and transparency, oversight, monitoring and redress, and we'll take a short look at future regulation. First, we're going to address how to determine your approach. When considering your AI implementation, you'll need to consider whether to adopt an initial top-down approach, where leadership mandates AI usage across the organisation. Alternatively, you might prefer an initial bottom-up approach, where staff identify potential AI use cases and implement them on a smaller scale, or a combination of the two, enabling strategic AI adoption and support coupled with practical grassroots problem solving and efficiency gains from low-hanging fruit. In the case of Hampshire and Isle of Wight Constabulary, they took this combined approach, identifying a specific AI project, the rollout of live facial recognition technology, to act as a testbed for wider adoption with the support of senior leaders and oversight bodies. When considering your approach to AI implementation, you will also want to consider how you will measure return on investment and wider success. In practice, this may require you to begin gathering data on how current workflows operate, taking into account both the time involved and the accuracy currently, so that this can then be compared with an AI-enhanced approach in due course. It's likely to be easier to measure return on investment in connection with bottom-up projects rather than projects whereby the whole organisation is told to start using AI. And it's worth bearing in mind that this data gathering may also support your legal and regulatory compliance by supporting an argument for necessity and proportionality. In the case of Hampshire's Live Facial Recognition project, they dedicated resource to conducting a specific operation seeking to reduce the number of outstanding warrants and to identify suspects, so they had a clear baseline of what was achievable and could also demonstrate that current methods just weren't getting the necessary results. Next, capacity, capability and culture. The Department for Science, Innovation and Technology's January 2026 AI Adoption Research Report identified that resistance to change remains a challenge in some organisations. AI implementation is a change management programme like any other and requires a focus on bringing staff along, engendering trust and confidence not only in the technology but in your motives as an organisation for why you want to adopt AI. A benefit of incorporating a bottom-up approach to AI adoption and implementation can be that it enables people who are already interested in AI to lead the way, establishing themselves as AI champions and validating AI use cases. Hampshire put together a team of people who not only had the relevant expertise, but had an interest in AI. AI implementation projects require multidisciplinary teams, potentially engaging multiple people across multiple specialisms. Information security, legal, not just commercial, but procurement, data protection, equality, human rights, IP, for example, information management, operations, human resources, sustainability, user representatives, employee representatives, learning and development, communications, diversity representatives, procurement, etc. So you need to ask yourself, does your organisation have the necessary expertise and capacity to take on a project? Do you need to bring in external support? In the Department for Science, Innovation and Technology's AI Adoption Research Report, it was noted that some businesses highlighted a lack of available time to look into potential AI solutions, explaining that staff were busy with day-to-day tasks, leaving no time to research or explore AI options. Hampshire and Isle of Wight Constabulary engaged us at Handley Gill to work with and supplement their in-house team, supplementing both their capacity and their expertise. AI literacy is the foundation of any successful AI implementation project. And by AI literacy, we mean the skills, knowledge and understanding that allow those developing, deploying and using AI to make informed decisions about artificial intelligence, to understand its opportunities, risks and potential harms, taking into account their legal and regulatory rights and obligations, and evolving ethical and responsible practice. In DCIT's AI Adoption Research Report, the second most prevalent barrier to adoption cited was limited internal knowledge or confidence in AI as a core problem. This created a barrier even before AI adoption begins, making it hard to evaluate or pilot tools effectively, with perceived unclear regulation and ethical concerns also featuring heavily. Not everyone has to be an expert in AI, and the level of AI literacy among staff can be tiered, but all staff working with AI need enough information to understand what AI is, how it works, what it can and can't do effectively, what the risks are, and how to use it effectively, both in general and in relation to the specific tool that they are going to be using. Recent scandals, including that relating to the Chief Constable of West Midlands Police, who was forced to resign having relied upon unverified AI output which was presented to Parliament, demonstrate the importance of using AI appropriately. In the context of the adoption of live facial recognition technology, this requires that everyone throughout the life cycle, from procurement through to the officers on the ground and the teams dealing with complaints, have that understanding of what AI is, how it works, how effective it is, whether and to what extent they should defer to it, how it can go wrong, and when to stop it. Next, establishing governance. If AI literacy is the foundation of any successful AI implementation project, AI governance provides the structural supports to enable you to take your AI implementation project to great heights. AI governance refers to the processes, standards and guardrails that help ensure AI systems and tools are safe and ethical, both when they are first developed, procured or deployed, throughout their use and when they are decommissioned. Elements of an AI governance framework are likely to include establishing and maintaining an AI governance board, developing an AI policy, establishing procurement gateways, creating a performance management framework, supporting risk identification, management and reporting, and undertaking consultation and delivering transparency. As we've said, AI implementation projects require multidisciplinary teams, potentially engaging multiple people across multiple specialisms. Your AI governance board should bring together representatives across the organisation, both the parts that want to use AI, those that will support them and oversee its use, and where applicable, those affected by it. Appointing a senior responsible owner for AI at the top of the organisation's leadership and to whom the AI governance board reports can help ensure that there is appropriate encouragement for and oversight of AI risks and opportunities in the organisation. This body should be responsible for setting requirements, authorising procurements, overseeing compliance, monitoring performance, taking and acting upon reports of concerns, and iterating policies and procedures. If you're starting with a specific project, like Hampshire and Isle of Wight Constabulary did, then your governance board could be project specific initially and grow or adapt from there. The reality right now is that in many organisations there is no explicit authorisation for nor prohibition of the use of AI, and many staff will therefore be using AI under the desk, creating legal, regulatory and reputational risk. Your AI policy should address the senior responsible owner and other individuals accountable for AI in the organisation, a glossary of terms, policy scope including application to suppliers, your objectives as an organisation and risk appetite in relation to the use of AI, how your wider ethical principles and values interact with the policy and AI use. It should refer to other applicable policies relevant to the use of AI, such as information governance, information security and DEI, or explain how those policies apply in the context of AI. It should identify authorised AI products and use cases, and those that are prohibited. Whether and in what circumstances personal data, confidential information and IP may be submitted to AI. A process for obtaining authorisation. Any qualifications before users are permitted to use AI, such as completion of AI literacy training. What logs and records are required to be maintained. The legal and regulatory requirements to be complied with prior to or when using AI. And AI transparency requirements. Other risk mitigations, contingency planning, phasing out and decommissioning, monitoring and risk management measures, and a mechanism for reporting concerns, contesting decisions, and obtaining redress. At Hampshire and Isle of Wight Constabulary, they implemented an AI policy specific for their live facial recognition rollout, and that was supplemented with other authorisation processes, procedures, and documentation. Next, procurement, risk management, and due diligence. Before enabling anyone in your organisation to procure or simply start using AI, you need a procurement gateway process to ensure that the AI that is used meets your legal and regulatory obligations, your operational requirements, and is actually effective. Due diligence should be carried out prior to procurement, not merely prior to deployment, by which point public funds will already have been committed. This is in accordance with the Information Commissioner's recommendation in its critical report on mobile phone data extraction by police in Scotland. That recognised that organisations should ensure they have DPIAs in place and should review and update such assessments prior to the procurement or rollout of new hardware or software. You should implement mechanisms to ensure that unauthorised AI tools aren't accessed and that your data isn't uploaded to them. You need to consider how you'll establish the efficacy, accuracy, and robustness of the AI that you propose to use, whether or not that's achieved through disclosure of information by the supplier, independent testing, and/or piloting and monitoring. What is appropriate will depend on the relevant use case and its risks. In relation to Hampshire's live facial recognition project, they procured a tool already in use by other police forces, and where the algorithm or model had been subjected to testing by both the United States National Institute of Standards and Technology, NIST, which conducts benchmarking, as well as by the UK's National Physical Laboratory, which conducted its own live testing of the tool, using volunteer officers and police cadets to test the system and evaluate potential discriminatory or biased outcomes and identify the configuration of the system at which there was no statistically significant difference in output based on gender or ethnicity. You'll need to consider what external testing or benchmarking you can rely on, or what testing you will need to carry out. Generally, when looking to procure AI models, be mindful that the EU has enacted and is implementing its own AI Act, which imposes much stricter regulations than in the US or UK. So where your supplier is based will also be a relevant consideration to the level of investigation that you should conduct. Legal and regulatory compliance and ethics. Depending on the nature of your AI implementation project, there are likely to be multiple laws, regulations and best practice that should be complied with. Public law, data protection, equality, human rights, negligence, confidentiality and IP. We'll take these one at a time. Starting with public law. You'll be subject to obligations of legality, relevance, ensuring that you give conscientious consideration to consultation responses, requirements of fairness, transparency. You may be subject to the government's Algorithmic Transparency Recording Standard, or ATRS. You may be required to give reasoned decisions, as well as subject to requirements of reasonableness and proportionality. When you're considering any AI system, you'll need to consider how you can achieve these requirements at the same time. That means black box AI models may well not work for you if they prevent you from giving a reasoned decision. In relation to data protection, you'll be required to comply with the data protection principles. These are lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and accountability. You'll need a lawful basis for processing personal data, which in relation to a public sector organisation is likely to be the necessity for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller, which the ICO says means if you could reasonably perform your tasks or exercise your powers in a less intrusive way, the lawful basis will not apply. If you're processing special category personal data, including biometric data, then you'll need further lawful basis under Article 9 of the UK GDPR, Section 10 of the Data Protection Act and Schedule 1, Part 2 of that Act. That's likely to be that your processing is necessary for the exercise of a function conferred on a person by an enactment or rule of law, or the exercise of a function of the Crown, a Minister of the Crown or a government department, and it's necessary for reasons of substantial public interest, for the prevention, investigation or detection of an unlawful act that must be carried out without the data subject's consent so as not to prejudice the purpose, and necessary for reasons of substantial public interest. But other lawful bases may be available, like safeguarding of vulnerable individuals or fraud. You may also need a lawful basis for processing criminal conviction and offence data, as set out at Article 10 of the UK GDPR, Section 10(5) and Schedule 1, Parts 1 to 3 of the Data Protection Act. You'll need to comply with obligations of transparency. You'll need a privacy notice, and that will require you to disclose the existence of relevant automated decision-making, including profiling, and at least in those cases to provide meaningful information about the logic involved, as well as the significance and the envisaged consequences of processing for the affected data subject. There are restrictions on solely automated significant decision-making using special category personal data, including biometric data, while the restrictions on automated decision-making have recently been relaxed by the Data Use and Access Act 2025, so that now only solely automated significant decisions based on special category personal data are restricted. You'll need to give consideration to those. You'll need to make arrangements to be able to comply with data subject rights, including to cease processing personal data. You'll need to make sure that you have appropriate accountability. Data protection by design and default means that you'll need to make sure that privacy forms part of whatever model you're either developing or procuring. You'll need to have a data processing agreement in place with any processors acting on your behalf. You'll need to maintain records of processing activities, ensure appropriate technical and organisational measures are in place to deliver security of data. And bearing in mind that the ICO considers that this requires that both confidentiality, integrity and availability of data are maintained. You'll need to conduct a data protection impact assessment. If necessary, you may be required to carry out prior consultation with the regulator, and you'll need to make sure that your data protection officer, if your organisation is required to have one, which for public sector bodies will be the case, is properly engaged. In relation to equality, Section 29 of the Equality Act prohibits discrimination in the provision of services, including subjecting someone to detriment in the provision of the service. And there is a prohibition of harassment or victimisation, and there must not be discrimination, harassment or victimisation in the exercise of public functions other than the provision of a service, in which case you're also under a duty to make reasonable adjustments. Section 149 of the Equality Act requires that in the exercise of functions you must have due regard to the need to eliminate discrimination, harassment, victimisation and other prohibited conduct, to advance equality of opportunity and to foster good relations between those sharing a protected characteristic and those who do not. That's the public sector equality duty. So you'll need to conduct an equality impact assessment. In relation to Hampshire and Isle of Wight and its deployment of live facial recognition technology, the practical impact of these obligations was not only the need to test the technology, but to be considered where it would be deployed, taking into account local amenities and potential alternative routes. Human rights law. Section 6 of the Human Rights Act 1998 specifies that public authorities must not act incompatibly with convention rights. Article 14 provides that the European Convention on Human Rights provides that the enjoyment of rights and freedoms under the ECHR should be secured without discrimination. Those rights include Article 8, the right to protection of private and family life, interference with which must be necessary, proportionate and in accordance with the law, which requires foreseeability. Article 10 protects the right to freedom of expression and information, and Article 11 protects the right to freedom of association. The use of live facial recognition technology presents a potential chilling effect on these rights. In the case of Crown on the application of Bridges and the Chief Constable of South Wales Police, the Court of Appeal found a violation of Article 8 when live facial recognition technology had been deployed at a protest, as the legal framework was insufficient to constitute the law, with critical defects found to be the lack of requirements as to who could be put on a watch list or where live facial recognition could be deployed, as well as findings that the data protection impact assessment was inadequate to meet the requirements of Section 64 of the Data Protection Act 2018. Excuse me, and that there had been a failure to discharge the public sector equality duty under Section 149 of the Equality Act 2010. In the case of Glukin and Russia, the European Court of Human Rights held that the use of facial recognition technology requires detailed rules and strong safeguards, limitations on the nature of situations which may give rise to the use of facial recognition technology, and requires that the intended purposes, the categories of people who may be targeted, the processing of sensitive personal data, and the nature and gravity of the offence in question, all relevant elements to be taken into account. Since the Bridges case, the College of Policing has issued its authorised professional practice on live facial recognition technologies. Although this largely identifies the circumstances and locations in which LFR could be used, rather than imposing restrictions, and therefore more is required. Hampshire and Isle of Wight Constabulary adopted its own policy and published that policy on when live facial recognition could be used, the authorisation procedure for deployments, the configuration at which the system would be used, who could be on a watch list, how locations would be determined, etc. The Protection of Freedoms Act 2012 also requires a compliance with the Surveillance Camera Code of Practice, and this requires a surveillance camera assessment to be carried out. While public sector organisations will not owe a duty of care to protect individuals from harm unless they assume such responsibility, such that, for example, a failure to use live facial recognition technology to identify a vulnerable individual is unlikely to result in a risk of being held to be negligent. Like any organisation, public sector bodies can be found to owe a duty of care to take reasonable steps to avoid foreseeable harm. How that will be held to apply in the context of the procurement and deployment of AI tools is currently uncertain, as is what the appropriate standard of care will be held to be. Nevertheless, Ensuring that you adopt a responsible AI governance approach with appropriate testing, monitoring and remediation will stand public sector organisations in good stead. There may also be context-specific regulations that need to be taken into account. We've already referenced the College of Policing's authorised professional practice on facial recognition, which applies specifically to facial recognition technologies, and there is also the Covenant for Using AI in Policing. Other use cases may have their own further context-specific regulations that must be complied with, including, for example, in healthcare, education, defence. And you'll not just want to ensure that you're complying with the obligations imposed on you, but to make sure you're protecting your own rights. You will want to impose measures to ensure that your confidential information, including personal data and intellectual property, is protected. This can be addressed through terms of contract with the supplier and preventing staff from uploading data to unauthorised AI models, as well as ensuring that you comply with your obligations of data minimisation. And you'll want to be aware that the UK has established its own responsible AI principles in the AI Regulation White Paper. Regulators are required to have regard to these in the exercise of their functions. Some of these obligations will overlap with existing legal and regulatory obligations, and others may go further. The principles are safety, security and robustness, appropriate transparency and explainability, fairness, accountability and governance, and contestability and redress. Other global responsible AI frameworks are more expansive. For example, the UNESCO recommendation on the ethics of AI also incorporates sustainability, the principle of do no harm, including a prohibition on mass surveillance, requirements for human oversight, and determination and literacy. Hampshire and Isle of Wight Constabulary sought to ensure effective human oversight, for example, by ensuring operators had received appropriate training and monitoring was in place to ensure that operators were and continued to exercise their own independent judgment and were prepared to second-guess an AI system's recommendation. So what does this look like in practice? Complying with all those obligations meant that prior to actually deploying the AI in the form of live facial recognition, Hampshire and Isle of Wight Constabulary prepared, with Handley Gill support, a range of documentation that included a live facial recognition policy document, standard operating procedure, a data protection impact assessment, a sensitive processing appropriate policy document, surveillance camera self-assessment, a community impact assessment, and a quality impact assessment. A collateral intrusion risk assessment, or that can be folded into other assessments, a human rights impact assessment, an operational risk assessment, a cybersecurity risk assessment, an algorithmic impact assessment, algorithmic transparency reporting, data processing, sharing or joint controller agreements, a data retention policy, creating live facial recognition approval records, creating live facial recognition operational documentation, various transparency measures, and establishing a partnership protocol with the mutual aid force. Many of these documents were then published online in order to maximise transparency and improve public understanding. Next, taking a step backward to spring forward. Having prepared all that documentation, the next step is actually preparing for deployment. In DCIT's AI adoption research we've referred to already, it was reported that fragmented, unstructured or siloed data was a technical barrier to deploying AI effectively, and that without clean, centralised data, AI models cannot perform accurately. The age, accuracy, and location of data is also an issue we encounter frequently when advising organisations on their AI implementation. Data will frequently be stored in Excel spreadsheets or PDF files and disaggregated across an organisation. It may also be out of date, non-compliant with data retention policies, conflicting with other data across the organisation, or otherwise of poor quality. It also likely lacks tagging or relevant metadata. So in practice, organisations often need to conduct a data cleanse and governance exercise before conducting a data consolidation exercise to gather relevant, validated and reliable data which can be input into a database from which it can be extracted and deployed for fine-tuning AI models. In relation to Hampshire and Isle of Wight Constabulary's deployment of live facial recognition technology, they had to undertake steps to ensure that any custody images that they held and they were considering including on a watch list were lawfully held, that they were relatively recent, to ensure that they were valid, that they were of sufficient quality to enable them to be included in a watch list. Consultation and transparency. In some circumstances, public bodies may have a public law obligation to conduct a consultation. Where processing of personal data is considered to have the potential to present a high risk to the rights and freedoms of individuals, a data protection impact assessment or DPIA must be carried out, and that should normally incorporate a consultation with affected individuals and/or their representatives. And in relation to AI adoption, there's also an argument for consulting more widely. When Hampshire was rolling out its LFR, it consulted with both its expert panel and with the forces community or user panel prior to deployment, and also engaged with the PCC and the ICO as data protection regulator. You may have legal and ethical transparency requirements. So for data protection purposes, people whose personal data is processed will need to be provided with information about the collection and use of their personal data, and where relevant automated decision making is carried out, to be provided with meaningful information about the logic involved, as well as the significance and the envisaged consequences of such processing for the data subject. For policing, subject to Part 3 of the Data Protection Act 2018, you have to provide data subjects with information about decisions, enable them to make representations, to obtain human intervention, and to enable the data subject to contest such decisions. But transparency in relation to a project such as LFR needs to be much broader and should reflect that the aim should be not only to maintain trust and confidence in public services and the technology, but to enhance it. That requires transparency vis-à-vis staff, regulators, all potentially affected parties, the media, and the general public. Transparency has to be meaningful, more than just updating a privacy notice on a website, although that should be part of it. Hampshire and Isle of Wight Constabulary created a dedicated web page related to LFR deployments, not only advertising but publishing underlying documentation and reporting the outcomes. It conducted internal and external communications exercises. Its PCC and officers went on the media and on social media. The deployments were essentially advertised in local media, and then on the day, prominent signage was erected on the approach to the deployment area so that people were well aware, in addition to the deployment of well-marked police vans, that live facial recognition was taking place. Oversight, monitoring and redress. When implementing an AI system, users are the first line of defence. They need to have a foundation in AI literacy, a specific understanding of the system they're working with, its purpose and limitations. They also need to ensure that they don't engage in what is referred to as cognitive offloading, where all thinking is essentially deferred to the AI without question. Users have to be empowered to employ their professional judgment and to second-guess the algorithm. Hampshire and Isle of Wight Constabulary implemented several steps so that the operator in the van had to confirm that they felt there was a valid match, having considered the LFR system's recommendation and its confidence score. Then they would transfer the potential match to a field operative, who would also make their own assessment when looking at the person in real life, and only if they were content that there was a potential match would they take action to engage with the individual. Note, not to immediately arrest them, but to engage with them. On screen now is the current deployment record published online by Hampshire and Isle of Wight Constabulary in relation to its LFR deployments, demonstrating the number of alerts, the number of interventions and the number of arrests or disposals, as well as the total number of faces seen by the system. Users are the first line of defence in relation to AI systems and should be encouraged to identify, log and report any unusual or unexpected outcomes. And systems should be set up to log how users interact with the AI, whether and when they disagree with the outcome, etc., to ensure that not only the system is working as expected, but that users are interacting with it as expected. All of this data should be overseen by the responsible owner and reported to the governance board with mechanisms for escalating any urgent issues, with a view to being able to temporarily cease use if necessary. Data protection law requires that individuals subject to relevant automated decisions are given the opportunity to make representations, obtain human intervention, and to contest such decisions. Contestability and redress is also one of the UK's responsible AI principles. Public sector organisations may also have their own complaints, processes and obligations. Hampshire and Isle of Wight Constabulary ensured individuals who were spoken to in the context of the operation were given information about their rights, directed to the dedicated web page on facial recognition and provided with a dedicated contact address to raise any questions, complaints or concerns. Any such contact should be monitored and overseen by the governance board as well as the responsible owner, with any learning fed back to inform both the developers and the organisation's wider policies and procedures. AI governance should always be an iterative process. Future regulation. The Home Office has recently conducted a consultation on a new legal framework for law enforcement use of biometrics, facial recognition and similar technologies. That consultation is now closed, but you can find our response to the consultation on our website. It didn't contain concrete proposals for regulation, but one of the issues under consideration was whether regulation should only apply to law enforcement or the wider public sector, and therefore local authorities considering deploying live facial recognition or other biometric technologies should be aware that there's potential future regulation in the offing. So that was a whistle-stop tour of how we applied responsible AI principles and legal and regulatory obligations to Hampshire and Isle of Wight Constabulary's adoption and deployment of live facial recognition technology. Using this QR code, if you scan the code, you'll be taken to a dedicated page on our website where you can access resources relevant to this topic. You can follow us. We're on X at Handley Gill Limited. We also run the dedicated AI Regulation UK account on X. We are on BSky Social at handleygill.bskysocial. We're also on Threads at Handley Gill Limited. You can find us on LinkedIn, where we post very frequently. You can access our website at www.handleygill.com and you can email us at info@handleygill.com. I'm Nicola Cain, the CEO and Principal Consultant at Handley Gill Limited, an award-winning legal and regulatory compliance consultancy. If you have any questions, either about our presentation today, about your organisation's development, adoption or deployment of live facial recognition or other facial recognition technologies, or about wider use of biometric technologies or artificial intelligence, then please do get in touch. My email address and LinkedIn profile URL are on the screen. Thank you for joining me and Handley Gill Limited today for Digital Leaders Public Sector AI Week 2026 on our presentation, Live Facial Recognition AI, from Recommendation to Reality.